Good evening or good morning, everybody. Welcome to Agora Dialogue's inaugural online oration in memory of Justice Ruth Bader Ginsburg, and a special welcome to our speaker, Mr. Julian Burnside. Agora Dialogue is a not-for-profit, non-partisan organisation which was founded in Australia, but which since 2016 has been operating primarily out of Europe and in particular from Cyprus. It runs a series of programs designed to promote and reinvigorate discussion around issues of justice and equity and how we might best live ethically and sustainably in the world. My name is Jenny Webb. I'm speaking to you from a beautiful late autumn day in Nicosia, Cyprus. I will be chairing this session. Our speaker, Mr. Julian Burnside, is joining us from Melbourne, Australia. At the end of the presentation, we will have a question and answer session. So please feel free at any time during the presentation or afterwards to enter a comment on the YouTube or Facebook page. Justice Ginsburg died at the age of 87 in September 2020. She served on the US Supreme Court for 27 years and was only the second woman ever appointed to that court, and the first Democrat appointed in 26 years when she was given that position by Bill Clinton in 1993. She was, to quote Joe Biden, not only a giant of the legal profession, but a beloved figure who stood for us all. A tireless and resolute champion of justice, especially admired, in particular by young women, and affectionately known as the notorious RBG, for her defence of the rights of women and minorities. We're very honoured to have, to deliver the inaugural Ruth Bader Ginsburg Oration, Mr. Julian Burnside, AOQC. The title of his presentation is Being in the Minority, chosen, I'm sure, to reflect Ruth Bader Ginsburg's own concern with the rights of minorities. Julian Burnside is a barrister based in Melbourne who practices commercial litigation, trade practices and administrative law, but is best known as a human rights and refugee advocate. Julian writes regularly for the press, is a published author who has written on a wide range of topics including climate change, language, the arts, ethics, human rights, law and justice. He's much sought after as a public speaker and is a very active member of his community. He has a strong belief in the need for change, and he does a great deal to help individuals and organisations find an effective means to access justice. Julian is especially well known for his opposition to the mandatory detention of asylum seekers in Australia and has regularly undertaken pro bono work on a range of human rights related issues, as well as acting in several major cases on behalf of Indigenous Australians. He and his wife, artist Kate Durham, set up Spare Rooms for Refugees and Spare Lawyers for Refugees in 2002, programs which provide free accommodation and free legal representation for refugees in Australia. He also has a great love of the arts and is a patron of numerous arts organisations and chair of the arts venue 45 Downstairs in Melbourne, which he co-founded, and also the Mieta Foundation. In 2004, Julian was awarded the Human Rights Law Award by the Human Rights and Equal Opportunities Commission and elected an Australian Living Treasure, an honour given to people who've made a particularly outstanding contribution to Australian society. In 2007, he received the Australian Peace Prize from the Peace Organisation of Australia, and in 2014, the Sydney Peace Prize from the Sydney Peace Foundation. In 2009, he was made an Officer of the Order of Australia, an AO, for service as a human rights advocate, particularly for refugees and asylum seekers, to the arts as a patron and fundraiser, and to the law. He's been an ambassador for the National Secular Lobby since 2017 and is a patron of the Asylum Seeker Resource Centre and of Agora Dialogue. And I'd now like to invite Mr. Julian Burnside to begin his presentation. Thank you, Julian.
Thank you very much, Jenny. I should perhaps offer just one minor correction. I was chair of 45 Downstairs from the time it was founded until maybe 6 months ago, but someone else is the chair now.
Okay, thank you.
Now, it's a great honour to discuss the life of Ruth Bader Ginsburg. She was born on the 15th of March 1933 to Jewish parents who both had Eastern European origins. Her father, Nathan Bader, was a furrier from the Ukraine. He was hit pretty badly by the Depression. Her mother's parents had moved to America from Poland. The mother was a factory worker and later a bookkeeper. And Ginsburg was once asked, what's the difference between a bookkeeper and a Supreme Court justice? And her answer was, one generation. Ginsburg's mother died on the day that Ginsburg graduated from high school. Very powerful and dreadful circumstance for her. She had instilled in Ginsburg a sense of independence and a love of learning. She took Ruth to the library throughout her childhood and stocked up the family's supply of books. Ginsburg recalls, my mother told me two things constantly. One was to be a lady and the other was to be independent. The study of law was unusual for women of my generation. For most girls growing up in the 40s, the most important degree was not your BA, but your MRS. And I had to look up what an MRS degree was. It's a marriage resulting from going to university with the sole purpose of getting married and consequently not completing the course. Ruth Bader, as she was born and raised in Brooklyn, New York, and with her parents, she attended the East Midwood Jewish Center, which was a conservative synagogue. For a woman who became famous for her dissenting judgments in the Supreme Court, she had a natural sense of being in a minority. She was Jewish and she was a woman. It's easy to forget that during the 1930s, anti-Semitism was virulent in America. Charles Coughlin and Jared Winrod publicly condemned Jews in radio broadcasts that they had, and in 1938, a poll reported that 60% of Americans had a low or very low opinion of Jews. It's easy to forget how women were treated in America and here in Australia until recent times. After all, Gloria Steinem first wrote about women's liberation in 1969. And that was the year that Germaine Greer published The Female Eunuch. It's very easy to forget how women's lib was viewed back then. I mean, it was, I think, seen as a strange aberration. Ginsburg went on from high school to study at Cornell University, where at the age of 17, she met her future husband, Marty Ginsburg. They met on a blind date. They married after graduation and soon had a daughter, Jane. Ginsburg said of Marty that he was the only boy I ever knew who cared that I had a brain. Very, very important message there. And apparently, he was, at any party they went to, he was the life of the party, and Ruth Bader Ginsburg, as she had become, was basically sitting in a corner all the time. So people would stand around listening to Marty, but if they wanted to discuss anything with Ruth, they would go over to the corner where she was sitting. She attended law school, not for women's rights works, but, as she said, for personal, selfish reasons. I thought I could do a lawyer's job better than any other person. I've no talent in the arts, but I do write fairly well and analyse problems clearly. That has got to be the understatement of a lifetime. But her feminist instincts were honed by her law school experiences. She and the other few women studying at Harvard met a lot of resistance and often hostility from senior faculty members. For example, in 1956, the dean of the Harvard Law School infamously asked Ginsburg and her 8 other female classmates why they were occupying seats that would otherwise be filled by men. Now, Ginsburg's female classmates have since reported on the experience of being a woman at Harvard and being treated as an oddity and with a lot of hostility. It's also useful to remember that when she was at Harvard, she was one of 9 female students in a faculty of 500 people. Now, during her time at Harvard, Ruth's husband, Marty, was diagnosed with cancer. During his illness and treatment, Ginsburg attended all of Marty's classes as well as her own and typed up all his papers, alongside caring for their daughter and helping him while he was ill. Even with those immense responsibilities, Ginsburg won a coveted seat on the Harvard Law Review, and making the law review at both Harvard and Columbia Law School was an unprecedented feat by any student, male or female. She was top of her class at Harvard and typically got no more than 3 hours sleep per night because she had a baby to care for and Marty to look after. Now, Marty recovered and secured a prestigious role as a tax lawyer in New York City. He was later recognized as the most significant tax lawyer in America. In her second year of law school, Ginsburg worked for a top-tier law firm in New York where she thought she had done a pretty good job and was expecting a job on graduation. But despite her performance, there was no job offer. Neither did she receive a job offer from any of the 12 law firms in which she was interviewed, and only 2 of them gave her a follow-up interview. This is a woman who had tied for first in her class when she graduated from Columbia Law School, and her Harvard professor, Albert Sachs, recommended her for a clerkship with Justice Felix Frankfurter on the Supreme Court. He wasn't ready to hire a woman and asked Sachs for a male recommendation. A mentor of hers, law professor Gerald Gunther, was determined to place Ginsburg in a federal clerk position, despite what was then a grave impediment, namely being female. He advised Judge Palmieri of the U.S. District Court for the Southern District of New York that if he didn't take Ginsburg, Gunther would never send him a clerk again. Palmieri eventually accepted her as his clerk. She held that role for 2 terms rather than 1, from 1959 to 1961. After her role as clerk for Judge Palmieri, Ginsburg was offered law firm roles but chose to work on Columbia Law School's International Procedure Project instead. She spent a year in Sweden to do this and learned Swedish for the purpose. As part of the project, she co-authored a book on Sweden's legal system and translated Sweden's judicial code into English. It's interesting that it was when she was in Sweden that she formed the view that Swedish law and society were much better for women than American law and society. In 1963, so when she was 30 years old, she joined the faculty of Rutgers Law School, where she discovered that her salary was lower than that of her male colleagues doing the same work. On discovering this, she joined an equal pay campaign with other women teaching at the university, which resulted in substantial pay increases for all the complainants. But then, prompted by her own experiences, Ginsburg began to handle sex discrimination complaints referred to her by the New Jersey affiliate of the American Civil Liberties Union, the ACLU. At the ACLU, she established the Women's Rights Project. Later, when she was a Supreme Court Justice, she said, "Women's rights are an essential part of the overall human rights agenda. Trained on the equal dignity and able to live in freedom all people should enjoy." The ACLU had been lukewarm towards women's rights issues. It took a person with Ginsburg's vision and leadership to establish the Women's Rights Project. She was steadfast in her belief that men and women would, as she said, create new traditions by their actions if artificial barriers are removed and avenues of opportunity held open to them. In the 1960s at the ACLU, Ginsburg wrote a brief in the case of Reed against Reed. It was arguably her first connection with what went on in the Supreme Court. Sally Reid had separated from her husband. When their son died, both parents sought to be appointed as executor of his estate. Idaho law automatically appointed the father as executor because he was a man. Her co-authors in the brief in Reid and Reid were Dorothy Kenyon, an early advocate for women's rights, and Pauli Murray, a brilliant African-American activist who had pioneered the argument for applying the 14th Amendment to women's rights. Ginsburg learned a lot from them, and she also learned how powerful the 14th Amendment could be. It was inserted in the US Constitution at the end of the American Civil War. It has 5 sections, but crucially the first section is the so-called Equal Protection Clause, and it provides all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive a person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, the 14th Amendment was obviously designed for the purpose of protecting African Americans from the mistreatment which had underlain the American Civil War. But during Reid and Reid in 1971, only 9 women in the whole history of the United States had ever been appointed to the federal bench in all of the American history. None of those women had sat on the Supreme Court. So Ruth Bader Ginsburg had to convince a panel of 9 male establishment-oriented judges for gender equality. As a progressive leader in advocating for inequity, Ginsburg had an ability to see cases through the eyes of someone who was skeptical of her position, but who was also capable of persuasion. Similarly, she wrote a seminal amicus brief. Amicus is friend, amicus curiae, friend of the court. So it's a person who is not a party to the litigation, but appears for a friend of the court. And she wrote an amicus brief in Craig and Boren in 1976, a Supreme Court decision which held that, and I quote, classification by gender must serve important governmental objectives and must be substantially related to achievement of those objectives. The plaintiff in Craig was a man who challenged an Oklahoma law permitting women to buy low alcohol beer at age 18, but not men. Ginsburg's goal was to convince the court to hold that the government must not rely on overbroad generalizations about different talents, capacities, or preferences of males and females when it makes law. The Supreme Court ultimately ruled that statutory or administrative sex classifications were subject to intermediate scrutiny under the 14th Amendment. And it was part of her skill as a lawyer that she chose a male client to argue that point. She argued many cases concerning the 14th Amendment. And
Julian,
yeah,
I'm sorry, I have been asked, I'm terribly sorry, I've been asked to interrupt you. Apparently there is a problem and I don't understand what it is, but maybe Eva can explain it to us. I can hear you perfectly. Eva, can you tell us what the problem is?
You can continue.
What?
She says you can continue.
Oh, I'm now being told that everything is good and you can continue. I'm so sorry.
Yep.
I do not understand what that was all about. Okay.
Okay.
I'm sorry.
Anyway, as I was saying, Justice Ginsburg argued in many cases that the 14th Amendment's Equal Protection Clause extends to freedom from gender discrimination, that included both sexes. Her first big case and advocate was a challenge to the law whereby a man, Charles Moritz, was unable to claim a tax deduction for the care of his elderly mother. The deduction by statute could only be claimed by women or widowed or divorced men, but Moritz had never married. The tax court concluded that the Internal Revenue Code was immune to constitutional challenge, but Ginsburg considered that rather than invalidate the statute, it should be applied equally to both sexes. She won in the lower courts. The government petitioned the US Supreme Court, saying that the decision cast a cloud of unconstitutionality over literally hundreds of federal statutes, and it attached a list of those statutes. Those statutes, Marty Ginsburg noted later, were the statutes that my wife then litigated to overturn over the next decade. It's fascinating that the government saved her so much work. And it was very much later that Ruth Bader Ginsburg noted that the government's list had saved her a lot of work. The fundamental rights which are guaranteed by the Constitution include voting, reproductive freedom, and the right to travel interstate. The fundamental right concept has limited utility in gender discrimination cases where often the female complainant has no right to a particular privilege, benefit, or advantage. Sex, like race, is a visible, immutable biological characteristic that has no nexus to ability. Ginsburg considered Reed and Reed to be the turning point for women in gender discrimination in the Supreme Court. She represented Sally Reed through writing the brief which she did. Sally Reed thought that she should be the executor of her son's estate instead of her ex-husband. The constitutional issue was whether a state could automatically prefer men over women as executors of estates. A strict scrutiny test applied rather than what the court considered the quote-unquote rational basis. It was argued that this was justified by a compelling government interest. The unanimous decision was in Sally Reed's favour. It was a unanimous decision. It was the first time in US history that the Supreme Court had struck down a state law because it discriminated based on gender, and it upheld a woman's complaint of constitutional gender discrimination. Now, that was in 1971 that the Supreme Court ruled in favour of Sally Reed. It was the first time it would strike down a law for treating men and women differently. The court ruled that giving a mandatory preference to one sex is, and I quote, the very kind of arbitrary legislative choice forbidden by the Equal Protection Clause of the 14th Amendment. In an ACLU memo, Ginsburg called the victory a small guarded step. In 1972, the year after Reed and Reed, the ACLU Women's Rights Project was born under Ginsburg's leadership in order to remove the barriers which were open and to open the opportunities which the 14th Amendment seemed to make available. She became the project's general counsel, as well as serving on the national board of the ACLU. At the time, she was writing the first textbook on sex discrimination law, text cases, and materials on sex-based discrimination, which was published in 1974. In 1972, Ginsburg also became the first woman to be granted tenure at Columbia Law School. She told the story of sex discrimination, of how it had been and how it had to end. Now, in 1973, Ginsburg took on another Supreme Court case on behalf of Sharon Frontiero. Sharon Frontiero was an Air Force officer whose husband, Joseph, had been denied the housing and medical benefits that female spouses of male Air Force officers received automatically. In writing which was both muscular and spare, Ginsburg expanded the scope of her brief to encompass the history of women's subjugation, with references to Alexis de Tocqueville and Alfred Lord Tennyson, and pared down the language to a precise and devastating argument. Brenda Feigen was a close colleague of Gloria Steinem and was then co-directing the Women's Rights Project with Ginsburg. She said of Ginsburg's submissions in Frontiero, "That's when it dawned on me how brilliant she is. She was at her most creative and profound. She told the story of sex discrimination, how it had been and how it had to end." Of her appearance in Frontiero, Ginsburg said, "I knew that I was speaking to men who didn't think there was any such thing as gender-based discrimination, and my job was to tell them it really exists." To make the point to the 9 men who were sitting on the bench, she quoted the 19th century women's rights advocate Sarah Grimke, who said famously, "I ask no favour for my sex. All I ask of our brethren is that they take their feet off our necks." She won the case. Brenda Feigen, who was by Ginsburg's side in court, said later, "There wasn't a single question from any of the justices. They must have been transfixed." She won in Frontiero, even though, as amicus curiae, she had just 12 minutes in oral argument. The Social Security cases illustrated how discriminatory laws designed to help women can harm men. In one of her later very famous cases, Weinberger against Weissenfeld, she represented a man whose wife had been the principal breadwinner and had died in childbirth. The husband sought survivor's benefits so he could care for his child, but under the then existing Social Security law, only widows, not widowers, were entitled to such benefits. She successfully challenged that law. Under the relevant legislation, a widow would have automatically collected the benefits, but Stephen Weissenfeld did not, because they were considered as mother's benefits. In Weinberger and Weissenfeld, she was carrying out a far-sighted legal strategy in the pursuit of women's rights, targeting a law that ostensibly benefited her sex because it also disadvantaged men. Interestingly, in Weissenfeld's case, she had Stephen Weissenfeld sitting beside her at the bar table for the entire case. She didn't introduce him to the court. She didn't say who he was, but I guess the court must have worked it out for themselves. Now, the Weissenfeld case was she argued it in the Supreme Court in January of 1975. At that time, women accounted for barely 5% of the attorneys who had argued cases in front of the highest court in the country. On behalf of her client, Ginsburg was fighting laws born of a time when women generally were not expected to work unless circumstances forced it, while men were expected to see worth and obligation in their outsized ability to earn money. She understood what it was like to suffer on account of being in a minority. In arguing why the unequal treatment of sexes was wrong, Ginsburg famously said that such a gender line helps to keep women not on a pedestal but in a cage. It reinforces the assumption that working for pay is primarily the prerogative of men. Interestingly, Weissenfeld's case won by unanimous ruling that became a milestone in the feminist movement's push to level the playing field at work and at home. Treating earnings as less or different because they were a woman's and not a man's was now contrary to the equal protection under the law. About 35 years after her argument in Weinberger and Weissenfeld, in the same courtroom where that case was heard, Ginsburg sat as the second woman to ever be appointed a Supreme Court Justice. She served 27 years on the Supreme Court, becoming its most prominent member. She was only the second female justice and the first Jewish woman ever appointed to the US Supreme Court. It was not her first appointment, though. In 1980, President Jimmy Carter appointed Ruth Bader Ginsburg to the US Court of Appeals for the District of Columbia Circuit. She is expected to be a liberal firebrand, but ultimately demonstrated the caution of a common law constitutionalist. She became quite good friends with Antonin Scalia, who was a judge on the same court, and often joined with him and Robert Bork in their opinions. Scalia, of course, was elevated to the Supreme Court in 1975, 2 years after Ginsburg. They remained good friends, but they rarely agreed with each other, and they were usually on opposite sides of a decision. Robert Bork, as many people listening will recall, was also nominated for the Supreme Court, but was not accepted because there were difficulties in his past. After Ginsburg had served 13 years on the Court of Appeals, President Bill Clinton appointed her to the Supreme Court of the United States in 1973. Ginsburg was only the second woman to be named to the Supreme Court, following Sandra Day O'Connor, and she was the first Jewish woman ever to serve on that court. On the bench of the Supreme Court of the United States, Ginsburg continued to fight for full gender equality under the 14th Amendment of the US Constitution. In 1996, she wrote the decision in the United States against Virginia, which struck down the male-only admission policy of the Virginia Military Institute and established a new standard review for sex discrimination cases. Over time, as the Supreme Court became more conservative in its approach, Ginsburg also became more pointed in her dissents. She came to be called the notorious RBG. That nickname came from a Tumblr account made by New York University law student Shana Kijnik in 2013. The Tumblr site is https://notorious.rbg.tumblr.com. It's really worth a look. Kijnik explained that it was the juxtaposition of Ginsburg's small stature and powerful presence that inspired her to create the nickname, influenced by the rapper called Notorious B.I.G., otherwise called Biggie Smalls. On the Supreme Court, she was famous for her dissents, but that's especially because the Supreme Court became increasingly conservative, whereas Ginsburg was regarded as surprisingly liberal. Now, liberal is an American expression. It does not mean the same thing in Australia. Conservative is much more like what liberal means in Australia. I don't think we have a word which properly describes someone who in America would be described as liberal. In any event, one of the cases in which she was in dissent was Lilly Ledbetter's case, who sued her employer, the Goodyear Tire and Rubber Company, in 1999 for gender discrimination after discovering that over the course of her 19-year career at the company, she had received lower compensation than her male counterparts. She won the case in the federal court in 2003 and was awarded $3.8 million in back pay and damages. But the relevant legislation had a 180-day charging period, in effect a limitation period. The tire giant, Goodyear, appealed, and the case eventually made its way to the Supreme Court. In 2007, the Supreme Court upheld a reversal of the federal court decision, ruling that because Ledbetter's claim was made after the 180-day charging period, she couldn't sue her employer under Title VII of the Civil Rights Act of 1964. When the court ruled against Ledbetter, who'd been paid much less for years than her junior male colleagues at Goodyear, Ginsburg's dissent included the following passage. The court does not comprehend the insidious way that women can be victims of discrimination. The ball is in Congress's court. a couple of years later, President Obama signed the Lilly Ledbetter Fair Pay Act of 2009. In 2013, a majority of the Supreme Court invalidated a key provision of the Voting Rights Act that required certain jurisdictions with a history of discrimination to undergo federal oversight before enacting any changes in voting procedure. In response to that, Ginsburg penned a fiery dissent, pointing out that Congress passed the latest installment of the Voting Rights Act with, quote, overwhelming bipartisan support. She added, the sad irony of today's decision lies in the court's utter failure to grasp why the law has proven ineffective. The insidious way that women can be victims to discrimination. She wrote that throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. It's the dissent in the Shelby case that grew Ginsburg's following in pop culture in recent years, spurring the notorious RBG moniker that morphed into a celebrity of the justice's legal career. Now, a few minutes ago, I mentioned the United States against Virginia military institution. That was one of the most significant majority decisions regarding gender inequality. In that case, which excluded women from military service based on sex, Ginsburg wrote the court's 7-1 opinion, declaring that it could no longer remain an all-male institution. Importantly, this was because it hadn't been able to provide exceedingly persuasive justification for making distinctions on the basis of sex. Although this standard fell short of the scrutiny test required in cases involving classifications on the basis of race, it nevertheless entrenched an important equality principle. The state, she said, could not exclude women who couldn't meet those demands. She went on, reliance on overbroad generalizations, estimates about the way most men or most women are will not suffice to deny opportunity to those women whose talent and capacity place them outside the average description. Inherent differences between men and women, we have come to appreciate, remain cause for celebration, but not for the denigration of the members of either sex or for artificial constraints on an individual's opportunity. Sex classifications may be used to compensate women for particular economic disabilities they have suffered, but such classifications may not be used as they once were to create or perpetuate the legal, social, and economic inferiority of women. She said that there should be no separate spheres for men and women under the law. Distinctions based on what most men or women do, on choices that most of them make, are an impediment to full equality. While there were surely physical differences between men and women, how the law dealt with them was socially constructed, not innate, and based on old-fashioned stereotypes. A woman's ability to bear children and the traditional division of labour associated with it too often contributed to the legal, social, and economic inferiority of women. Ginsburg had said it before as an advocate, and in the majority decision in US and Virginia, she said it again. Over the years, before she went to court, Ginsburg would file dozens of briefs seeking to persuade the courts that the 14th Amendment guarantee of equal protection applies not just to racial and ethnic minorities, but to women as well. As her place on the court grew in seniority, so did her role. In the 2000 US presidential election, Florida was the key to victory for both the Democrats and the Republicans. But the voting process in the state of Florida was a mess, with poorly designed ballots and counting irregularities. You will remember George W. Bush and Al Gore both declared victory in Florida before election night was over, kicking off one of the most drawn-out election results in the nation's history. The election quickly went from a decision steered by voting counts to one steered by the courts. There were hanging chads everywhere. The bitter court battle first went to Florida's Supreme Court, where a manual recount of ballots was ordered. The Bush campaign immediately asked the US Supreme Court to stay the decision and halt the recount. The order was appealed up to the US Supreme Court, where it was reversed, and Florida's 25 electoral votes, along with the presidency, was handed to Bush. Although Ginsburg was not on the winning side, she didn't go gentle into that good night. Notably, Antonin Scalia was in the majority. While Ginsburg's colleagues in dissent wrote that they dissented respectfully, she only said, "I dissent." In her dissent, she said, "I might join the Chief Justice were it my commission to interpret Florida law. The extraordinary setting of this case has obscured the ordinary principle that dictates its proper resolution. Federal courts defer to state high courts' interpretation of their state's own law. This principle reflects the core of federalism on which we all agree." She also said, were the other members of this court as mindful as they generally are of our system of dual sovereignty, she concluded, they would affirm the judgment of the Florida Supreme Court. Another of her very famous dissents was the Hobby Lobby case. At issue in the Hobby Lobby case was a Health and Human Services mandate, which would have required David and Barbara Green and their family franchise business Hobby Lobby to provide and facilitate 4 potentially life-terminating drugs and devices in their health insurance plan, but that was against their religious convictions. The alternative was that they would have to pay severe fines. The Greens argued that the mandate substantially burdened their religious beliefs in violation of a federal law, which was the Religious Freedom Restoration Act. In an opinion by Justice Alito, the court said the plain terms of RFRA, the Act, made it perfectly clear that Congress did not want to discriminate against men and women who wished to run their business as for-profit corporations in the manner required by their religious beliefs. Our responsibility is to enforce RFRA as written under the standard that RFRA provides. The HHS contraceptive mandate is unlawful. She wrote in her dissent that the court had ventured into a minefield, adding that it would disadvantage those employees who do not share their employer's religious beliefs. Any decision to use contraceptive made by a woman covered under Hobby Lobby's plan will not be propelled by the government. It will be the woman's autonomous choice informed by the physician she consults, she wrote. She also noted that the cost barrier that many women face in attempting to gain access to different kinds of birth control. And she said it bears note in this regard that the cost of an IUD is nearly equivalent to a month's full-time pay for workers earning the minimum wage. In July of 2020, the US Supreme Court paved the way for the Trump administration to expand exemptions for employers who have religious or moral objections to complying with the Affordable Care Act's contraceptive mandate. In what turned out to be one of her last dissents, Ginsburg lambasted the court for leaving women workers to fend for themselves in a case where the justices struck down the Affordable Care Act's contraceptive mandate. She said, "Today, for the first time, the court casts totally aside countervailing rights and interests in its zeal to secure religious rights to the nth degree. This court leaves women workers to fend for themselves, to seek contraceptive coverage from sources other than their employer's insurer, and absent another available source of funding, to pay for contraceptive services out of their own pockets." She noted that the government acknowledged that the rules would cause thousands of women, between 70,500 and 126,400 women of childbearing age, to lose coverage. When the case's oral arguments were being heard, Ginsburg participated from a hospital bed because of a gallbladder condition. She also announced, weeks after her dissent in the case, that a scan the February before had revealed lesions on her liver, and she had begun bi-weekly chemotherapy. She had been diagnosed in 1999, the year before, with colon cancer. She underwent surgery, chemotherapy, and radiation therapy. All of that without missing a day of service on the bench. When she had to appear in court as a judge, she would do so by either Zoom or whatever the equivalent was in the year 1999-2000. 10 years later, she was diagnosed with early pancreatic cancer and went back in court within 12 days of her successful operation. In 2010, her husband Martin died of his cancer just 4 days after their 56th wedding anniversary. They had had a most spectacularly successful wedding. Justice Ginsburg persevered in serving the court through recurrences of her cancer, promising to remain on the bench as long as she was able to serve. She died at her home in Washington, as Jenny mentioned, in September of 2020, September last year, at the age of 87. The world mourned her death. As a feminist icon, a great legal mind, and a giant of history. The evening of her death, crowds gathered on the steps of the Supreme Court to pay tribute to a champion of equal justice under the law. Although she was only the second woman on the Supreme Court, she later shared the court with two women, Elena Kagan and Sonia Sotomayor. On her death, she was replaced by Amy Coney Barrett, with whom she would not have agreed. In America, Ginsburg was regarded as a liberal, as distinct from a conservative. As I said, I don't know what the equivalent Australian words are. She wasn't exactly radical, but she was a far-sighted thinker. Arguably, the nearest equivalent we have in Australia is Michael Kirby, frequently in dissent, but usually pointing the way to the future. But unlike Ginsburg, Kirby is not the subject of a number of films and various documentaries. Ginsburg did not retire during a Democratic term, but died on the 18th of September last year from complications of pancreatic cancer. Trump was still president and lost no time in appointing Barrett in Ginsburg's place. Although the Supreme Court can function with 8 justices, in the absence of Ginsburg, it was instantly rendered more conservative. With Ginsburg, the history of the United States Constitution is, and I quote, the story of the extension of constitutional rights and protection to people once ignored or excluded. That's especially true in the circumstance of African Americans and of women. The fact is that This approach impacts the ability of the court to interpret legislation from abortion to voting rights and from racial segregation to LGBTQ issues. But before announcing Ginsburg's replacement, the previous President Donald Trump paid tribute to Ginsburg as a legal giant and a pioneer for women who'd inspired Americans for generations to come. Now, Justice Barrett is statistically indistinguishable from other conservative judges appointed by President Trump. During her time as a judge on the Seventh Circuit, she didn't always decide cases, Ginsburg that is, didn't always decide cases in line with other conservative judges and sometimes ruled in a liberal direction. This will likely continue to establish a very strong Republican conservative presence on the federal judiciary. She was born in 1970. Barrett was born in 1972, so she was only 48 when Trump appointed her, making her years younger than the next youngest. The other Trump appointees are Kavanaugh, who was born in 1965, and Gorsuch, who was born in 1967. The US Supreme Court will be conservative for a very long time to come. In fact, I'd say the history of the US Supreme Court is probably the biggest argument in support of the Australian requirement that judges have to retire when they're 70. It does waste some judges, but it means that judges who are not up to the mark can't damage things for too long. Democrats and disadvantaged minority groups are not convinced that Justice Barrett, with her originalist interpretation of the Constitution, would protect many people in society. As a Trump-appointed federal judge on the Seventh Circuit, Barrett's positions on matters such as health care, including the Affordable Care Act, workers' rights, racial and ethnic equality, consumer rights, immigrant rights, gun safety, and the rights of low-income defendants in criminal cases are concerning to Democrats and advocates of social justice. Overturning the landmark abortion case of Roe versus Wade would be only the tip of the iceberg, but the likelihood of overturning that decision is small considering the political controversy it would create. But Barrett's presence on the court only makes the transition easier for the Conservative bench to get a 5-vote majority on future cases, including any case that raises the question of Roe versus Wade. And there is an argument, I think, that Ginsburg should have left the court before the end of President Obama's term in order to permit him to choose her successor. There are concerns of how politicized the court has become and the conservative policy preferences of the Republican Party could impact on the significant changes that Ginsburg made to American law. If she had retired during Obama's presidency, it would have permitted him to select young, relatively progressive judges who would be able to remain on the court for future decades and continue the work of Ginsburg's legacy. As it happens, of course, the relatively young judges appointed to the Supreme Court by Trump will probably call those shots. When he nominated Ginsburg to the Supreme Court, Clinton said, "Ruth Bader Ginsburg cannot be called a liberal or a conservative. She has proved herself too thoughtful for such labels." And the Dean of Harvard Law School said on Ginsburg's death, "Justice Ginsburg personified the best of what it meant to be a judge. We've lost a giant." And some of Ginsburg's famous quotes: "Real change, enduring change, happens one step at a time." She also said, "Reacting in anger or annoyance will not advance one's ability to persuade." Although in connection with that, she also said, "Sometimes it's useful to be deaf." She said, I'm a very strong believer in listening and learning from others, and reading is the key that opens doors to many good things in life. Reading shaped my dreams, and more reading helped me to make my dreams come true. She said, famously, you can disagree without being disagreeable. Very important point. She also said, don't be distracted by emotions like anger, envy, resentment. These just zap energy and waste time. Women belong in all places where decisions are being made. It shouldn't be that women are the exception. She said, I ask no favour of my sex. All I ask of our brethren is that they take their feet off our necks. And she said that she would like to be remembered as someone who used whatever talent she had to do her work to the very best of her ability. I have no doubt that is the way Ruth Bader Ginsburg will be remembered. Thank you. Thank you, Jenny. I've caught you off balance.
No, that's there. I thought Eva was going to bring me back up. That was fascinating to hear so much in so much detail about her extraordinary journey through life. A woman of enormous courage, a great dissenting voice, and obviously one which we all have so much to learn from, and from her achievements and fine mind. Now, we do already have some questions, so if we could move straight into the question from the chat section, first of all, from Professor Stephanie Lalhas-Shayelu. Thank you, Stephanie. Stephanie says, very well done. If not covered yet, I was wondering whether we could expand on what lessons we can draw from her life in view of today's gender equality and diversity goals. What would be the message to young legal professionals?
Well, that's a very interesting question. I think at the moment in law school, it's roughly 50-50 men and women. But in the profession, at least in Melbourne, Australia, where I am, the majority of practitioners are men. And it is really important to bear in mind that women face a real disadvantage in the profession. Mind you, it's not like what Ginsburg faced with Felix Frankfurter, who didn't want to think about having a female associate, or whatever they call them over there. In Australia, there are lots and lots of women who are very senior in the profession. For example, our High Court has a female Chief Justice, and I think three other women on it. So the majority of women on our High Court are female. And the Chief Justice of Victoria is also female. So women set a very fine example in Australia of whereabouts the profession can take them. So I don't know if that answers the question, but I think in terms of lessons that we can draw from her life, the main lesson is just don't give up. Form a view about what the system needs and pursue that one step at a time. It was very skillful on her part to choose men very often as the applicant or appellant in cases that she took to the Supreme Court under the 14th Amendment. Very, very clever, because it then didn't look like a women's rights case. But that's because women were treated so differently then. I'm not a woman, so I can't say whether women are treated differently now.
Okay, thank you. Then we have a question from Maria Dikeo in Melbourne. I'm going to actually amalgamate two of her questions. She asks, why was she able to achieve what she did? What made her so different from her colleagues and peers? Can her success be attributed only to her fine mind?
She undoubtedly had a fine mind, and that's very important. But she grew up knowing what it was like to be a minority. She grew up as a woman at a time when being a woman was a greater disadvantage than it is now. And she grew up as a Jew. And that, it's fantastic. I had to do quite a bit of research to see how Jews were treated in America in the 1930s. 1933, the year she was born, was the year Hitler came to power in America. Now, the way Jews were treated in Europe does not tell you a great deal about the way they were treated in America. But in America, and perhaps even in Australia too, they were treated pretty badly. I think her experience as a member of a minority made it an important difference in the way she handled problems like that when she came onto the bench. Mind you, that said, it is interesting that she made common cause with Antonin Scalia when they were on the Court of Appeals. That changed when she was on the Supreme Court, and what she said made a real difference. So I don't know if that adequately deals with the question.
I'm sure it does. And we have another question from the chat box from Jamie Dorney in Melbourne. How do you think the Equal Protection Clause of the 14th Amendment sits with affirmative action policies? For example, Conservative Justice Clarence Thomas uses the clause to oppose affirmative action.
The 14th Amendment is fairly clear in its terms. I haven't read any of Clarence Thomas's judgments, so I don't know how he manages to turn it to conservative ends. It's really interesting, actually, bearing in mind the historic origins of the 14th Amendment. I don't hold Clarence Thomas in very high regard, so I guess I can't answer that question adequately.
Okay. Now, Kliakos Kyriakidis has a number of questions for you, and I think he may be able to join us and ask them. Are you there, Kyriakos? No? Okay. So I will ask them on his behalf. The first question, he says, flows from two facts. One is that Ruth Bader Ginsburg was born in the US in 1933, the year of Adolf Hitler's rise to power in Berlin. And she went on to spend part of her childhood experiencing the devastating after effects of the Second World War. The second fact is that around the world today, almost all government ministers, parliamentarians and judges were born after the end of the Second World War in 1945, and as a result, they have no individual or collective memory of either the war or the wider Nazi German epoch in Europe from 1933 to 1945. With all this in mind, are crucial lessons of 20th century history at increased risk of being overlooked to the severe detriment of members of minorities or others? If so, what can be done about it?
I agree with the proposition. I think a knowledge of history is very important, and it's been lost. Mind you, that could have been said with equal force at other times in history. I mean, knowing a bit about the origins of the US Civil War, I think is quite important when you consider what the Equal Protection Clause in Amendment 14 is all about, because that was designed to prevent what had happened to African Americans before the Civil War. So what do what do you say for people in America who don't remember the case of Dred Scott? I mean, Dred Scott was one of the triggers for the US Civil War. Dred Scott was an American slave. He was born a slave, and his owner was a doctor who travelled to free states with Dred Scott in tow, and after his owner died, Dred Scott brought proceedings saying that he was no longer a slave, relying on English authority to the effect that if a slave enters a free country, their condition of slavery is forever dissolved. That's the argument that he ran, and certainly there is an English case from some while before which stands for the proposition that if a slave, it starts with the very interesting idea that the air of England is too pure for a slave to breathe. So on that basis, the statute, the condition of slavery is dissolved. Dred Scott took his case to the US Supreme Court, which decided against him and said that, in effect, once a slave, always a slave. Now, I guess the Equal Protection Clause must have meant very different things to people who grew up with a knowledge of the Dred Scott case. It's a shocking decision. It's really alarming. But the relevant provision of the 14th Amendment says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So how that was clearly designed to prevent cases like Dred Scott from ever being decided the same way. And incidentally, although I never met Ruth Bader Ginsburg, I did meet Antonin Scalia when he was travelling around Australia. And he said that the Dred Scott case was arguably the worst decision of the US Supreme Court. And that's Scalia. So, the knowing history is useful.
Yes, indeed. Another question from Kyriakos. This is on, he would like to hear your views on the issue of positive discrimination with respect to members of minorities. Is positive discrimination a fair means of addressing inequality and the injustice which normally flows from inequality? Or is positive discrimination antithetical to the principle of meritocracy and as such a potentially fresh source of inequality and injustice?
I think, introducing measures that combat inequality is a good idea, but it should not be so done. It shouldn't be done in a way that will produce further inequality. It shouldn't be done in a way that is available only to members of the group that are previously the subject of discrimination. And I mean, Reed and Reed is an interesting example of that. And Weissenfeld's case is an interesting example of that. I mean, how it comes down to the rather simple proposition that justice should be done for all people, and it's no good if justice or a law designed to combat injustice inflicts other injustice. It's just no good. So each individual case needs to be seen on its own merits.
Okay. And Kyriakos' third question is for the benefit of female law students or newly qualified female lawyers. So it takes us back, I think, to Stephanie's question. For the benefit of female law students or newly qualified female lawyers in those parts of the world which are male-dominated or characterised by institutional forms of religious discrimination, Ruth Bader Ginsburg successfully managed to confront both patriarchy and religious discrimination from within the US, a flawed democracy, but a democracy nonetheless. However, is it really possible for a female law student or newly qualified female lawyer to follow her example and successfully confront a systemically discriminatory domestic legal system if that system is within a totalitarian, authoritarian, or otherwise undemocratic society?
It's going to be very difficult, of course. But I guess anyone who's working in a system like that should approach the problem the way Ginsburg did. Think of devices which might enable you to use the discriminatory laws in order to achieve a better outcome. I mean, I don't know. There's a great deal of, if you're thinking of third world countries, there's a great deal of assumption that needs to be made. But I would say never give up. Any system that claims to be a justice system should operate to the advantage of those who are otherwise not receiving justice.
Okay, it sounds like John Rawls.
Well, yeah, John Rawls is very. I think his theory of justice is pretty good.
So do I. There's another question from Jamie Dorney, which I think you may already have answered, but so his question is, do hyper-partisan conservative appointments to the Supreme Court threaten both democracy and the rule of law in the US?
Yeah, it's an interesting question. I think they could threaten democracy, but only because the rule of law would be upheld. If it's the rule of law that enables hyper-partisan conservative appointments to achieve objectives that we would see as incompatible with democracy. So it'll threaten one or the other, but not both, in my opinion. But maybe I'm just a mad optimist.
Okay, I can't see any more comments or questions in the chat box. So maybe if I could just ask one. When I was thinking about your subject before today, I went back and looked at John Stuart Mill's section in On Liberty on the tyranny of the majority and his harm principle and so on. And I noticed that at the end of that section in his work on liberty, he has something which I think is really quite interesting. And I guess this is his long-term utility argument, which one would expect from Mill. He says, men have more to gain by allowing each other to live as seems good to them than by compelling each other to live as seems good to the rest. Now, I take that to mean that he's suggesting we'll be more successful, more sustainable as a society over time if we allow people to live as they think best, as seems good to them, rather than imposing a majority view on how they should live, presumably within the parameters of the law and presumably in accordance with his harm principle. So it's not so much about rights or the rights of the individual as about understanding that we each have a notion of what constitutes a good life and that a good society is one which respects that individual conception. Just wondering if you think that's a useful way to think about how a society or a community might or should respond to minority groups or minority views within it.
It's a good start, but I think it may run into problems. I think it may run into problems in circumstances where the rights of the majority do not mesh neatly with the rights and interests of the minority. I think I'd like to take that one on notice.
Okay, well, I think we might leave it there. I can't see any more questions. So on behalf of everybody listening, either today or in the future, thank you so much, Julian, for another wonderful insight into this amazing woman in whose honour this oration has been held today by Agora Dialogue. I trust that many people will have a chance to watch it. I certainly hope so. Thank you very much indeed.
Thanks, Jenny.